Hey guys, welcome back. Sorry. Hey guys, welcome back to another episode of Lawyered Up. I am your host, Jared Moore, and I am not a lawyer. I saw that we had David Ware posted a question already in the chat. I'm going to get to that, David, and thanks for tuning in today. If you're watching this later, I'm going to get to that question, but it's going to be later on in the stream when I wrap up the other stuff. Before we get into what we're going to be talking about today, I wanted to mention, if you are a candidate for office in the upcoming Creek Nation election and you want to participate in our Meet the Candidate video series, which is starting today. In fact, tomorrow I have Galen Cloud scheduled at 6 p.m. if you guys want to tune in for that. If you want to participate in that Meet the Candidate video series, you need to email me at jmoore@mvskokemedia.com. That's the letter J, M-O-O-R-E, and we'll get you all scheduled. The days are going to start running out. We have to have all these done before September 16th. So the last one could be scheduled on September 16th because September 17th is the first day of early voting. And then also absentee ballots go out on 8/21. So if you want the at-large audience to see your video, you need to kind of try to get scheduled with me for yours to happen before 8/21. Okay, so with that out of the way, let's start off here. I'm going to pop this up and we'll just begin because what we're going to be talking about today is the recent filings in the Grayson-Kennedy case. So we are at the Supreme Court's website. We're going to go to opinions. We're going to scroll down here and we're going to click this and we'll see down here, you guys may have seen the coverage about down here at the bottom, the appellate's petition for rehearing that was filed on August 4th. And I waited to do a live wire until the respondent's objection to rehearing on August 11th dropped, which was yesterday. So we've got both of those on here now. And then the next thing will be the order deciding whether they're going to have a rehearing. We'll get into that in just a second. First, I wanted to point out some interesting stuff that's in the petition for rehearing. The first thing I'm just going to, and you guys, there's links to this stuff in the description of the video if you want to go and read the entire thing. I'm going to read their points here with one specific thing that I'm interested in. So rehearing is required because the opinion ignored facts and law that establish the existential retained right of the nation's citizens in the future to impose requirements for citizenship that precludes people, including freedmen descendants, from citizenship in the nation. So this first argument that they have here is an argument that they did present at the oral arguments, and the Supreme Court heard this argument. So that's the first one, is something that was heard. Number two, the opinion violates the Constitution by physically amending the Constitution. That's the second argument that they make. I don't know if that might be a misunderstanding there, but that's the opinion there. Number three is the opinion's unnecessary determination that the Constitution's membership requirement was void ab initio renders the nation's governmental operations since the adoption of the 1979 Constitution legally infirm. So that's another argument they're putting forth. Number four, the opinion's invalidation of all constitutional, statutory, regulatory provisions using blood reference determines issues not before the Citizenship Board, the District Court, or the court in this appeal. That's the one I want to take a look at, but before we go to that, the opinion's command for administrative action in non-existent cases and as to which relief is not presently sought in this court is beyond this court's jurisdiction. That's the fifth argument. So the thing I wanted to point out here in looking at this is, let's go to page 14, because this is something that when I was reading this, caught my eye. It was something that I mentioned to you guys in the previous live stream. So 14, let's see here. I'm just going to read this stuff so we can get on the same page here, guys. The opinion extends its unnecessary void ab initio language beyond the constitutional citizenship requirements to unnamed constitutional, statutory, and regulatory provisions that utilize a by blood reference, not at issue in the district court and unaddressed by it or order under review. Courts are required to hear actual cases and controversies, not hypothetical ones, and so on. Although not expressly identified in the opinion, the broad void ab initio mandate appears to encompass certain constitutional and statutory provisions requiring a full citizen's minimum 1/4 blood quantum for office holding. Constitution Article 3, Section 4 requires that the chief and deputy chief, there's a mistake, he's the second chief, he's not deputy chief, but I'm going to go on, hold full citizenship. Constitution Article 6, Section 2C requires all members of the National Council to hold full citizenship, likewise, so on and so forth. Now, the reason I wanted to mention that with you guys is this is what I was talking about is this is what we're reading is the filing of the Citizenship Board in this case. So the Citizenship Board's lawyer is saying, hey, if the Supreme Court's void ab initio of by blood that is in the order stands, it's going to affect these blood quantum requirements for office, for holding office, right? So you could infer there that that's what the position of the Citizenship Board, that the Citizenship Board believes that if we get rid of by blood from the Constitution, right, void ab initio, then that also makes it where these blood quantum requirements for office go away. And the reason I wanted to mention that is because if anybody does in the future file any cases at the district court to challenge the blood quantum requirements for running for office, they could reference this filing by the Citizenship Board and say, hey, look, the Citizenship Board's legal opinion is also that this gets rid of that blood quantum requirement. Now, they're using it in this as an example to say, hey, we need to rehear this case because this didn't get addressed, right? So grain of salt there. They can always issue a different opinion. I'm talking about the Citizenship Board could always say, well, we were just trying to get a rehearing or whatever. But I did want to call attention to that because I thought that was interesting. That was something that I had heard from some citizens that they were going to do, but it also looks like they probably did do it. And the Citizenship Board is saying, yeah, also we think that that's true. So interesting development there. Okay, if you guys want to read the entire petition there, you can click it and read through it. I'm going to move on to the respondent's objection. So what this is Grayson-Kennedy's lawyers, their objection to a rehearing. Now they're going to quote some rules here. Specifically Rule 24, appellate rules for the MCN Supreme Court. And you may be asking yourself, where do you get these, or what are the rules? Like, for instance, when the petition, before the petition was filed, the petition for rehearing was filed, we published a story where we got a comment from Chief saying that they were going to file this petition for rehearing. I had never heard of that. I was like, can you do that? And luckily, Connie Dearman, who is the Supreme Court clerk, sent me in the direction of some regulations. And I wanted to show you guys where those are so you could see what these are. Basically the rules for if you want to appeal a Creek Nation Supreme Court decision, you want to have your case reheard. So let's see, how do we get to those? So we start on the Supreme Court's main webpage. Let me pop this up for you guys so you can see. We go code, right? Once we get to the code, we want Title 27, Judicial Procedures, right? Now down here, you will see that there's Admin Order 2025 Appellate Rules of Procedure, and so on and so forth. Now what we're looking for, these appellate rules of procedure are going to, the ones that are going to apply are going to be the ones that were in action when the case was filed. And if we look here, let me go back up. The case number here is SC 2023-10. That means this case was filed in 2023. So we need to look at this one right here, the 2023 Appellate Rules of Procedure. Okay. If you guys get lost at any point of this, let me know. So what we're looking at here is these are the actual rules. Let me get the pages over here, and what we're looking for is Appendix 2, Mvskoke Creek Nation Supreme Court Rules of Appellate Procedure. And we're going to scroll down here because they are referencing in their brief, let me make sure, Rule 24. So let's find Rule 24 and see what it says. Rule 24, Petition for Rehearing. So again, these are the rules of how you file a petition for rehearing. A, time. A petition for rehearing before the Supreme Court may be filed within 10 days after the decision of the court has been rendered, and the adverse party shall have 7 days thereafter in which to serve and file objections thereto. So before I go any further, let me bring this up. We're just going to go through and check and see if they met these deadlines, right? So we've got the order and opinion was issued on 7/23, and then the petition for rehearing was issued on 8/04, which looks like it's within that 10 days. And then the respondent's objection was filed by 8/11, which also looks like it's within that 10 days, or 7 days, I'm sorry. So B, and this is what the opposition filing is, hold on, let me get rid of that. This is what the opposition filing is focusing on, is the 2 grounds for a rehearing. So these are B here says grounds. A petition for rehearing may be presented on the following grounds and no others. So these are the only 2 scenarios where you can file a petition for rehearing. Number 1, that some facts material to the decision or some question decisive of the case submitted by counsel was overlooked by the court, or 2, that the decision is in conflict with an express statute or controlling decision to which the attention of the court was not directed. So those are the 2 things that you can file a petition for rehearing on, okay? And then I just want to continue on a little bit. It says procedure. The rehearing may be held with or without oral argument and will be decided only upon the petition and the objections thereto. And then it says second petition for rehearing. No motion or application for rehearing or review will be accepted for filing after the denial of a petition for rehearing. And then it says when no petition for rehearing may be filed. No petition for rehearing may be filed for the following types of orders: an order denying an application to assume original jurisdiction, and an order denying a motion to dismiss with prejudice. Okay, so let me come back in and we'll kind of go over what all of that is. So basically, what they're saying is, normally when you're filing something like this petition for rehearing, the lawyer who files that will say, hey, I'm filing for this petition for rehearing, and according to the rules for this, I've got to meet these grounds, and this is how I've met those grounds. I see you guys popping up in the chat, and I'll get to it, but now the Citizenship Board's lawyer in his petition for rehearing did not do that. He did not outline what the grounds are and then point out how he has met the grounds, or he or she or whatever. So that's what they're talking about here in the opposition filing. Is it says Rule 24, which governs petitions for rehearing, specifies, and we went through all of that. It says appellate instead bases its arguments on an impermissible third ground because it thinks this court was incorrect. So that is, and this is the opposition filing, so they have the opinion that it shouldn't be reheard. So that's basically their whole argument for the opposition to the filing, is that none of the arguments put forth by the petition for rehearing fit into those 2 things for grounds for petition rehearing. and you can go through and read the petition for rehearing and see if you think any of those 5 things fit into there. I think that maybe, this is just my opinion, I think that maybe that blood quantum issue for running for office could fit within that facts material to the decision, or some question decisive of the case submitted by counsel were overlooked. I think maybe you could fit that in there, but we'll have to see what the Supreme Court decides. I went through and read the appellate rules, all of those. I did not see anywhere, and I could have missed it, but I didn't see anywhere a time frame that requires the Supreme Court to issue an answer to this, to say, yes, they are going to have a rehearing, or no, they're not. So I'm not for sure, the 2 steps of filing the petition and then filing the opposition to the petition, those steps do have a time frame, 10 days and 7 days. But for the Supreme Court to make their decision, I couldn't find anywhere that said for sure that they have to do their decision within a time frame. Okay, I'm going to start wading through these comments as best I can. Let's go up here. David Ware is asking, please talk about the role of Mvskoke Constitution vis-a-vis the Treaty of 1866. It makes no sense if the Constitution is invalid. The United States Constitution is not limited, and neither should ours be otherwise. We're only allowed what the federal government says we can. Bible citizenship is valid. It must be mandated. Okay, David, so first off, you've got some misconceptions there. The United States Constitution is limited. The United States Constitution itself says that it has to follow all the treaties that it made before the Constitution was created. So the United States Constitution, we can't pass an amendment that invalidates a treaty that the United States made before the Constitution or at the ratification of the Constitution. So that's the first misconception there. And that's kind of also what I would talk about with, if you go back and look at the oral arguments on this case, the breakdown that was published. The justices point out that there are places in our Constitution that says we are going to follow all of the treaties that the Creek Nation entered into, as well as other things like our cultural norms, et cetera, et cetera. The Constitution that we have right now was passed in 1979, which I'm sure that you know. And in those oral arguments, they went over the Constitution that was passed, that was created right after the 1866 treaty, that included the ability for freedmen to be in the tribe and have representation and all of those things, right? So go check that stuff out for those questions. And as far as the answer to that, I don't know. I mean, there's litigation going on right now. No. The Citizenship Board is not stating an opinion. It's asking for clarification from what I've read. What is the status of the Ron Graham federal case? That I have not heard. Ron Graham's federal case, the last time I checked it, which I think was like last week, is still like in a stay. Nothing. They're waiting for this case. I think they're waiting for this to get settled all the way. If the rehearing is granted, could other parties file amicus briefs? So, T.Y. Prohl, what it looks like is, if the Supreme Court decides to give a rehearing, they can do so and have the rehearing without any oral arguments. In fact, there probably won't be oral arguments. There's not going to be any new evidence or anything submitted, because if you looked at those rules, let me pop those rules up again. It says, sorry guys, where did I see that? Oh, here it is. Procedure. Number C right here. Procedure. The rehearing may be held with or without oral argument. So they can have oral argument if they want it. And will be decided only upon the petition and the objections thereto. So basically, they could say, yes, we're going to have oral arguments, but you're only going to be limited to things you brought up in your petition or things you brought up in your objection to the petition. You're not going to be able to argue just totally different things. So to me, that says they probably wouldn't allow any type of amicus briefs, because the amicus briefs are typically saying, that's kind of like what the amicus briefs do in any cases, to say, hey, I'm going to be affected by this case, and I think you guys should look at this other issue that nobody's talking about. Okay, so moving on. Could there be an option for the freedmen to create their own tribes, so to speak, and go about things that way? Well, I don't know. It's possible under the Indian Reorganization Act, I guess, maybe, but we haven't seen that happen yet, and don't know if things are moving on that front or not. And honestly, at this point, if you're on the freedmen rolls, things are going your way. It would, you wouldn't need to go and try a whole different method. Everything's going according to plan for them. Could there be please discuss the canons of legal determinations outlined in the Citizenship Board's petition that are alleged to have been neglected in the application of the court's decision. Okay. We will try that. Appellate's thing. Like I said, I am not a lawyer, but I want to go down and canons, opinions and validation of constitutional. T.Y. Pearl, could you tell me which section you want me to look in specifically for those canons? Because I don't see them listed on here, but I remember that there are some canons in here because I read that word a couple of times. Which argument is that presented in? Let me move on while I'm waiting on him to respond. The Constitution was overlooked. We have our session. Wrongly applying some of the canons of the Constitution, which the opinion determined applicable. Opinion, page 17, actually impeaches us. One treaty must be Did the order override the Bigler ruling on dual citizenship in tribal towns? So if you guys don't know what the Bigler ruling is, there was a case a few years ago, and this I don't think went to the Supreme Court. So if I had to say whether it was going to affect that decision, basically Judge Bigler ruled in a district court decision that it was okay for, well, hold on, let me step back a second. The Constitution, the Creek Nation Constitution, says you can't be enrolled in another federally recognized Indian tribe. Okay? There was a candidate that ran in a race, and that candidate had citizenship in the Creek Nation, and he also had citizenship in one of the federally recognized tribal towns. I can't remember which one it was. I think it was Kialiji. Might have been Tlaloc or Alabama Kasadi. They are separately federally recognized, okay? That candidate's candidacy was challenged, and there was a court case hearing on it, and Judge Bigler in the district court ruled that because those other federally recognized tribal towns were part of the Creek Nation culturally and historically, that you could be enrolled in one of those tribal towns and in the Creek Nation, right, as a citizen. Now, that case was not challenged up to the Supreme Court, which is what probably should have happened, and because the Supreme Court are the ones that should make a decision on the Constitution, or whether something violates constitutional provision. Okay. Now, would this decision, right, the by blood void ab initio order, affect that previous decision? I don't know if it would. That didn't really. We would need to look and see. Really, that case would need to be challenged up. You would need to go back and take that dual citizenship case and go to the Supreme Court and get a Supreme Court ruling, and then you could put those two Supreme Court rulings and see if they conflict, right? Because right now you have a Supreme Court ruling, and the dual citizenship case was the district court, It never went up to the Supreme Court for whatever reason. And so a Supreme Court ruling is always going to overrule that precedent's going to be higher than a district court ruling. Sorry. Wrongly applying some of the canons construction with the opinion page. The opinion? In general, the canons are: 1, treaty must be liberally interpreted in favor of tribes or tribes in question. 2, treaty must be construed as the Indians understood. 3, doubtful or ambiguous expressions in the treaty must be resolved in favor of the given Indian tribe. Right. So those canons, and this part I'm just going to talk about my opinion of the oral arguments, what happened in the oral arguments. And what T.Y. Proles here is talking about, you guys, is like whether the treaties, whether parts of the Constitution are violating a treaty based on these canons of law. So how they address that in oral arguments is the Supreme Court justices pointed out that there was a Constitution that was enacted right at the Creek Nation right after the treaty was signed, and that Constitution contained things that had the freedmen in the tribe and have representation. The point being that, or from the justice's standpoint, that we agreed to these things, right? And that addresses those canons to say, well, the tribe gave up some rights or in the treaty, or that they are interpreting what the treaty says incorrectly, right? The problem you got to overcome with that is they had a constitution that had representation assigned to freedmen towns. So that's the problem. Treaty provisions that are not clear on their face must be interpreted from surrounding circumstances and history. Absolutely. And that's kind of like what they talked about in the oral arguments. I don't think that line for the citizenship board is going to pay off if they get a rehearing. I wouldn't bother going down that road because the justices explored that a lot, and they're not going to change their mind on that particular issue. I think that actually probably swayed some of the justices that were on the fence to say, well, the 1867 Constitution had these provisions in it for freedmen, and then also there were discussions that happened afterwards. That's gonna have a problem for your argument there. Now our Creeks can be able to run for office instead of having certain individuals who have run for decades. Well, we'll have to wait and see on that. If there's not a rehearing, if the rehearing gets denied and the order stands, I'm just going to check and see if this got updated. No. I had some stuff happen with the Supreme Court's website earlier that I think we might be seeing a decision on this petition this week. We'll just wait and see. But if the Supreme Court's order stands, right, you would still probably, depending on the attitude of the election board and the citizenship board, have to see another court case go through about those the blood quantum requirement for office. And if I was just imagining a case like that, right, my imagination would be somebody filing something that says, hey, I wasn't allowed to run in this race because my blood quantum isn't right, and the Supreme Court has ruled that by blood is void ab initio, so I should have been allowed to run for office. For that type of a case to work, that person would need to go file to run for office and get denied, right? That's the first step. And then you would take your denial and you would go to the district court, you would look and see if there's an administrative procedure, just like what happened with the freedmen citizenship. You would look to see if there's an administrative procedure, and if there is, you go through that, and then you would go to the district court, and we would probably go all the way up to the Supreme Court, maybe. There is a very slim chance that the election board and the citizenship board would just say, okay, cool. Everybody, the blood quantum requirement for office doesn't exist anymore. Now, that's what the Citizenship Board's lawyer is arguing in this. He's saying if by blood is void ab initio, then the blood quantum requirement for office doesn't exist. So they would have to explain how they had their lawyer argue one thing in one case and argue a different thing in another case. But we'll find out what they do in the future, and that's happened before at the nation. So let me take a look here. India in the Supreme Court decision is anyone that's part of the nation. Can Supreme Court stay implementation of the order until Ron Graham case is decided in federal court? So now I would need to look at the exact filings in Ron's case, but I believe that Ron filed a motion in his case that was I'm trying to remember the terminology for it. I don't have it right here, but it's basically saying that he's asking that they put a stay on the case until this other case gets decided, right? Now, remember, Ron's case is also, he's suing the Department of the Interior and other people. So it would make sense for him to say, hey, can we put a stay on this suit I have against the Department of the Interior and the BIA and Deb Haaland until I get a ruling out of whatever comes out of the Creek Nation Supreme Court? Because if the Creek Nation Supreme Court rules for the Freedmen, that's going to help him in his civil lawsuit against them to say, hey, look, the Creek Nation Supreme Court says, agrees with me, and so on and so forth. So I think that's what happened in that case. In other words, the Supreme Court, the Creek Nation Supreme Court wouldn't stay their implementation because of Ron's case. It doesn't have anything to do with them. You know, it's like his case is actually going to hinge on this decision, not the other way around. Having blood quantum then means absolutely nothing. Yeah, pretty much. David, you should go watch the interview I did on our channel about CDIBs, because it'll blow your mind that there's a whole bunch of information in it. And I talked with the guy who wrote the article, who was a former in the Attorney General's office of Navajo Nation at the time that this was published in a legal journal. But go check that out. Can court order elections be halted and candidate filing be redone without the blood quantum restriction? So again, and I'm not a lawyer. This is all just my speculation and my opinion. But I do think that the process to challenge the blood quantum is a citizen that doesn't have the quantum to run needs to file to run and then get denied. That would be the first step, is you got to file with the election board to run. The election board would review that application and deny you, and then you would have grounds to file your next suit. As far as redoing the election and all of that stuff, since nobody did that part, I think it would be hard. Now, if you got your case into court, right, like if you did file to run in this election and you got denied based on your blood quantum, well, there would be one little step in there that would be the hiccup. So your application would need to be judged of what the legal consensus was at the time you filed. So if you filed your application before the Supreme Court issued this decision, then they could deny you. And even right now, if you ran over there and filed to run in this election, if it were possible, the decision isn't in all the way, right? Once the Supreme Court decision is in all the way and it's solidified, there's no more ability to have a rehearing or anything like that. That's when you want to go try to run and then get denied and then go to the district court. Then all citizens should be full citizens with the previous decision. Yes. There's going to be a decision this week because the Supreme Court stated, okay. Can you discuss the details of the failed attempt of Ron and Grayson, the Freedmen Band's application to establish a Freedmen federally tribal town? I can't talk about it because I don't really know anything about it. I haven't talked to them about that. When was BQ created and was we before then? What's BQ? Tyree, I don't know what BQ is. Can you explain the tribal town, why the tribal town was denied by the feds? I don't know. I haven't followed that. I don't know enough about that TUI Pro to talk about it. So heritage means nothing then. That is sad. Well, actually, David, you should go check out the oral arguments and look at what the 1867 Constitution said. That's the Constitution that was before the 1979 Constitution. That will open your eyes a lot about how the tribe operated. For instance, I'm sure maybe you've heard of the House of Warriors and the House of Kings and those things. The 1867 Constitution actually carried over more pieces of how the government was run from before removal than the 1979 Constitution, because the 1979 Constitution is kind of a replication of the United States federal government, how it's structured with an executive branch, legislative branch, et cetera, whereas the 1867 Constitution did include some things like House of Kings, House of Warriors that were pre-removal governmental bodies. As a Supreme Court Justice saying Freedmen was part of the signing of the first Constitution. I don't know about if it was the 1867 the first Constitution. I don't know. Well, anyway, we're kind of blood quantum. Oh, okay. So when was BQ created and what was we before then? So that blood quantum was created during the Dawes Rolls and so on and so forth. So there's a lot of history. We have some videos on it on our channel if you guys want to check it out. I think that's all I had to talk about, and I've tried to answer your questions there, guys. There's a lot of stuff that I don't know, and I'm not a lawyer, and even the lawyers don't know, and they're all trying to figure out what the rules are. I do think this is just... I do think we're going to see a decision on this rehearing by the end of the week. I would hope that we would see it as soon as possible so we can, if there is going to be a rehearing, we can go on down the road and get the oral arguments and all that stuff. And if it gets denied, then that will have exhausted all of the possibilities to not enact the order, because as you saw here, let me pop this up really quick before we get out of here. As you saw here, when no petition for rehearing may be filed, no petition for rehearing may be filed for the following types of orders, and so on and so forth. So there's no ability to file a second petition for rehearing. Please discuss the Rogers ruling about white Cherokees and how that impacts freedmen under McGirt. I haven't seen that yet, the Rogers ruling. I'll have to check that one out. But we are, hold on. Can you state a year or so we can see it was less than 50 years ago? I don't know if that's for me. So that being said, guys, we are 38 minutes in, and we've talked a lot about, or I've been talking a lot, and you guys in the chat are really talking a lot. I'm going to do, if you are a candidate, let me run through this again because I'm going to do it at the start and the end of all the videos during the election season. If you're a candidate for office at the Creek Nation and you're watching this video and you want to be part of our Meet the Candidate series, you can see on our YouTube the Meet the Candidate series. We do it every election. Send me an email. The email is the letter J, Moore, M-O-O-R-E, at mvskokemedia.com, and I will get you set up with a time and a link to a meeting to do the Meet the Candidate video. And if you guys are watching this, you're like, what's Meet the Candidate? Meet the Candidate is a live stream just like this where I have, or just like Liveware, where I have a candidate for office come in. You guys can ask them questions from the chat. I will have questions to ask them. They don't get the questions ahead of time. It's basically a good faith thing for all of the at-large citizens who can't attend the community meetings down here or the community forums. And just a note, because I have seen on social media people asking if we can live stream and that type of thing. We don't have any control and don't have anything to, I'm talking about Mvskoke Media, doesn't have any control or anything over the community forums with the candidates, and a lot of times we aren't even notified when they're happening. Last election, we went to the editorial board of Mvskoke Media to see if we could go and try to hunt these things down and live stream them. And the decision we got from the editorial board is that if Mvskoke Media can't attend all of them and live stream all of them, then we shouldn't do any of them. So that's the decision that we're operating under now, is since we don't have any control over when and where they happen, and a lot of times we don't know beforehand that they are happening, then we can't possibly get all of them. And so we're going to just stick to what we normally do, which is the Meet the Candidate videos. If you guys are citizens out there and you're watching this, and that is a big step for a candidate to take, is to come on a Meet the Candidate video, because as we've seen with prior Supreme Court cases, some of their things that they say in those videos could come back to haunt them if they want to become a Supreme Court justice, as what happened in this case. So you should encourage them, if you want your candidates to answer your questions, tell them, do a Meet the Candidate. You go to their Facebook or their campaign and say, I'm a Mvskoke citizen. I want you to contact Jared, and I want you to do a Meet the Candidate because I got questions for you. So, all right. With that being said, it's been a pleasure, you guys. And I'm going to do another lawyered up when we get well, I might do one depending on what the order says. If we get a rehearing, definitely. If we get a denial of the rehearing, maybe not, because there won't be much to talk about there. But, and then tomorrow, candidate Galen Cloud is going to be on at 6 p.m. If you got questions for Galen, tune in. We also have right now Will Lowe on Friday, the 15th at 6 p.m. We've got Sandra Golden on the 20th at 6 p.m. And then on the 22nd, we have J.R. Wind at 6 p.m. Those are the ones I've got scheduled. And then again, if you want to participate and meet the candidate, let me know. And you guys encourage that out there. So appreciate you guys. And we will see you next time. Mado Hadum. Chihichat, please.